Let's go to Colorado now, the father figure murder trial. This hour, we have some unentered testimony to play for you. Prosecutors say that the defendant in this case, Darin Thrailkill, strangled to death his girlfriend's 6-year-old little boy named Martin. This happened 10 years ago. The defense says Martin suffered from asthma and other complications that led to his death. Before we go into the testimony from the ex-wife, here is how both sides presented their arguments during openings.
Mr. Thrailkill's conduct was taking no accountability as a parent. His demeanor is inconsistent with learning of Martin's death. Lack of action that Mr. Thrailkill takes is really not in line with the gravity of the situation. And what Darin Thrailkill does in that moment is nothing. He denies hurting Martin and blames everyone else for everything.
When looking for a homicide, it's easy to miss or downplay clues that don't fit. Clues that, along with other indicators of asphyxiation as cited, show that something else was going on. Clues that later led to further medical testing and ultimately revealed the real possibility that Martin stopped breathing because he was sick, not because he was strangled.
So that's how they set it up. One of the key witnesses in this case for the state was Chantel Thrailkill. Now, this is the defendant's ex-wife, but not the mother of little Martin. She had 2 other kids with the defendant. Let's see what she has to say.
Do you have 2 biological children named Sean Thrailkill and Alexandria Thrailkill?
I do.
And who is the father of those children?
Darin Thrailkill.
Were you married to Darin Thrailkill?
Yes.
At some point in time?
Yes.
And the Darin Thrailkill you're referring to, is he in the courtroom today?
Yes.
And can you just describe, first of all, where he's seated?
To the right or left and over there.
To you. How about your right or left?
To the left.
Which way is your right and which way is your left?
Sorry.
Are you nervous?
Yes, I'm very nervous.
Yep. Is he seated to the right or the left of you?
He'd be on the left.
Okay. Can you describe where he's seated? Is he seated at a table?
He's on the left. He's on the right. Sorry.
Okay. I'm not trying to trip you up.
You're good.
Okay. Is he seated at the table?
Yes.
And is he the only male at the table?
Yes.
And what is he wearing?
A suit with an orange shirt and a black tie or a blue tie.
Thank you. I would ask the record reflect the identification of the defendant by Ms. Thrailkill.
Is there any objection, Ms. Parham?
No.
Okay. The record will so reflect. Thank you.
Did you and the defendant divorce in 2012?
Yes.
When did that divorce become final that year? Do you recall?
July 13th, I believe, of 2012.
Back during 2012, did you live here in Grand Junction?
I did.
Did you live at 585 25 and a half Road?
Yes.
Is that Paradise Valley unit did you live in?
161, I believe.
I'll come back to that in just a minute. Back in the day when you lived at Paradise Valley Trailer Park, did Darin Thrailkill, the person you identified, live in the same place or did he live in Delta?
Through the divorce, he lived in Delta.
And one of the reasons I asked you to identify the Darin Thrailkill that you're talking about is, did he also have a father by the name of Darin Thrailkill?
Yes.
The Darin Thrailkill that you were married to, did you call him Darin or did you call him Levi?
Either or.
Did he also?
There were times that I would call him Darin. There are times that I called him Levi.
Levi was a nickname he used?
Yeah, middle name, yeah.
Okay. Back in March of 2012, you were living on 25 and a half Road at the trailer park. You said Darin was living out in Delta at that time. Is that correct?
Yes.
During that period of time, were the kids going back and forth with some shared custody?
Yes.
On March 26th of 2012, if I may have just a moment, Judge.
Yes, you may.
And the parties are asking the court to give a limiting instruction that this is evidence for the limited purpose that we have previously used for the 2012 incidents. If you need us to approach, I'm happy
If you
to.
can approach just to make sure I get it correct. Thanks. Feel free to stretch.
All right, sidebar there. Let's get a break and get you back into that Colorado courtroom when we return. Stay with us. Back to Court TV Live. I'm Ted Rollins in for Julie Grant on this Thursday. This hour we are in Colorado for the father figure murder trial. Prosecutors say that the defendant, Darin Thrailkill, strangled to death his girlfriend's 6-year-old little boy named Martin nearly a decade ago. But the defense says Martin had asthma and other complications, and that's what led to his death. Here's more from the defendant's ex-wife on the stand.
Ladies and gentlemen, with regard to the evidence you're about to hear, I'll give you this following instruction that you're to follow. Evidence of any other act is not admissible to prove a person's character in order to show that on a particular occasion, the person acted in conformity with the character, but can only be used for the following purposes: identity, motive, intent, or lack of mistake or accident. And that was the same instruction I gave you with regard to Ms. Osinski's test during a part of her testimony. So I'll just refer you back to that for that same language. If I think you all took it down a second time and we went through it pretty closely. So thanks. Ms. Mayor?
Thank you, Judge. Ms. Thrailkill, on March 26th of 2012, did you contact Delta County Sheriff's Office to report possible child abuse?
I don't remember if it was Delta County or Grand Junction.
Okay. Do you recall Sean coming home from a visitation and observing injuries?
Yes.
Judge, if I may approach, I've shown defense counsel 1100 through 1107.
Sure, thanks.
Ms. Thrailkill, I'm showing you what has been marked for identification as People's Exhibit 1100, 1101, 1102, 1103, 1104, 1105, 1106, and 1107. Have I shown these to you prior to coming into court today?
Yes.
At least as regards to 1100 and 1101, what are those photographs of?
The trailer that we lived in?
And what trailer number was that?
251, I was wrong.
Ultimately, after you contacted police, did a Grand Junction police officer actually come to your home and do photos while you were present?
Yes.
Do these appear to be the photos the officer Travis Wright took?
Yes.
Are 1100 and 1101 fair and accurate as to where you were living at the time?
Yes.
People would move for admission of 1100 and 1101.
Ms. Parham, do you have an objection?
We just maintain the previous objections we had to this evidence.
Okay, the objections are overruled. 1100 and 1101 are both admitted.
As it relates to the other exhibits, is 1103 a fair and accurate representation of what Sean looked like the day the officer came out to your home?
Yes.
And are you actually in this photo holding him?
Yes.
People would move. Is this fair and accurate of what Sean looked like?
Yes.
People would move for admission of 1103.
Any objection to 1103?
We just maintain our previous objections to this evidence.
The objection's overruled. 1103 is admitted.
And as it relates to these other photographs, do these appear to be fair and accurate representations of the injuries that you remember existing across Sean's torso?
Yes.
Are they a fair and accurate representation from what you remember?
Yes.
People would move for admission of 1102, 1104, 1105, 1106, and 1107.
Ms. Parham?
We'd maintain our previous objections and also object to the number of photographs as cumulative.
Can I see those exhibits, please? Thank you. Thanks. The objections are overruled. 1102, 1104, 1105, 1106, and 1107 are all admitted. Sure.
If we could first publish 1100. This is where you lived on 25 and a half Road.
Yes.
And if we could please publish 1103. Is this what Sean looked like March 26, 2012?
Yes.
And you indicated, is that you holding him when Officer Wright took this photograph?
Yes.
And if we could please publish 1102. What do you remember about his injuries?
They were deep. It took up most of his backside. And they were very wide.
And if we could publish 1104. And this would be his backside.
Yes.
If we could please publish 1105. If we could publish 1106. So we're looking at Sean's left side. Basically, we've looked at from his back around to his front side. Is that right?
Yeah.
And if we could publish 1107. Thank you. When Sean returned home, did you follow up by taking Sean to a doctor?
I did.
Was that Dr. Whistler at Western Colorado Pediatrics?
Yes.
Were you aware of whether or not CPS got involved?
Yes.
Were you aware of whether or not they interviewed Sean about these injuries?
Yes.
I don't have anything further. Thank you.
Ms. Parham, any cross?
Yes.
Okay, whenever you're ready. Thanks.
Okay, they get set for the cross. Matthew Mangino, boy, this is huge for the jury to hear. Prior incident, other kids abusing. It is a game changer for the state. What is the bar for this to be let in? Because this is an incident that didn't have anything to do with little Martin's death, you could argue, and the defense, I'm sure, opposed this vehemently in pretrial motions. How does the judge weigh what shouldn't come in something like this that is, it's a game changer because it's showing the jury the true colors of this individual?
Well, right, Ted. It's showing, prior bad acts, and specifically, it's showing conduct which amounts to child abuse, and that's the focus in this case that ultimately led to the death of a 6-year-old, which indicates that this death was a homicide. So these prior bad acts shows some pattern of abuse of children, and as you said, it's devastating for a defense. I'm sure the defense fought this. There's a curative instruction which was given to the jury, or cautionary instruction. But the bottom line is, this jury just heard that the defendant has a history of child abuse, and they're listening to a case about the death of a 6-year-old. So it is devastating to the defense.
Yeah, there's no, I can only imagine jurors sitting there watching this, looking at those photos of the boy's back, and then just turning their attention to the defendant with disgust, because he's convicted right there from the ex-wife of abusing a child, and then the 6-year-old magically dies in your care. It's game over.
Yeah, I agree. I mean, I've been involved in cases, excuse me, where, prior bad acts have been at issue, and you literally fight tooth and nail to keep that out, because that, jurors are human. They're going to listen to this and they're going to hear some sort of consistent pattern of abuse when your client's being tried for murder of a 6-year-old. As you've indicated, and I agree, this could be the end of the show for the defendant in this case.
Yeah, well, let's get a break. When we come back, we'll have the cross. See what the defense attorney tries to do with the ex-wife to maybe change the narrative a bit. We'll see how that goes. Plus, a live look into that courtroom in Florida. They're done with their charge conference, meaning next up is more testimony in the adopted son murder trial for Dima Tower. Stay with us.
Mama tried. Now my daddy's crying because I'm in here.
You are the common denominator that led to JD and Big Doug shooting each other in the dark of night.
All right, help party, I'm dying.
Don't you have the blood of both these men on your hands?
I felt guilty for that.
You felt guilty because, frankly, you were guilty.
Interview with a Killer. New episode Saturday night at 8 Eastern and Pacific. Only on Court TV.
On July 2nd of 2016, is that a date that sticks out in your memory?
Yes.
Why?
Lost my baby.
Did defendant Darin Thrailkill remain a parent-like figure in Martin's life on that date?
Yes.
Court resumes in the father figure murder trial later today for Darin Thrailkill. He's accused of killing 6-year-old little Martin, his girlfriend's son. Prosecutors believe he reached a breaking point after the child had a bathroom accident. The defense is saying, well, the poor Martin had pneumonia and asthma, and that's why he died. Right now, we're listening to key testimony in the state's case. The defendant's ex, just on direct examination, detailed with photographs how the defendant had abused one of their kids. Now it's time for the defense to try to rehabilitate the defendant through the ex-wife on cross. Let's see how they do.
And this report was made at the end of March 2012, right?
Mm-hmm.
And sorry, can you say?
Yes.
And that was at the beginning of, or I guess the middle of a divorce with Mr. Thrailkill.
Yes.
I think you all had separated in December of 2011.
Yes.
And there was a contentious, or I guess it was a contentious divorce and custody case at that time.
Yes.
And the day after you reported this, you requested a copy of the report to use in the custody case.
Yes.
And you remember talking to DHS, right?
Yes.
And there were several days between your initial report and when DHS came out to talk to Sean.
Mm-hmm. Yes.
And he was staying with you during that period.
Yes.
And Sean said different things about what happened.
Yes.
And you heard different things about what happened from different people.
Yes.
You were at the house when Sean talked to DHS.
Yes.
And you believed you irritated them by trying to, quote, help Sean along.
I don't know.
Okay. Do you recall speaking with the district attorneys, and their paralegal, Ms. Weimer, on October 16th, 2025?
Yes.
And during that interview, you indicated that you believed you irritated DHS by trying to, quote, help Sean along, end quote.
Yeah. I don't remember, but yes.
Okay. And you were married to Mr. Thrailkill for several years, right?
Yes.
And the only kind of physical discipline you ever saw was spanking.
Going to object beyond the scope of direct examination.
Ms. Parham?
I think this fits well within the scope of direct examination.
The objection sustained.
And so this isn't the only time you've talked to DHS, right?
Yep. Yes.
And after Martin's death in 2016, you spoke to DHS several times.
I'm going to object again beyond the scope of direct examination by years.
And these statements get into the credibility of this witness. She gave multiple inconsistent, reportedly false statements to DHS in 2016.
I'm going to object to counsel providing a narrative. The court would like to handle this at the bench. We're objecting as to outside the scope and relevancy.
Okay, if you can approach, thanks. Feel free to stretch.
All right, sidebar there, Matthew Mangino. The defense strategy here, obviously there's more to the story about the abuse photos, and you're a liar, because in a contentious divorce, people do anything. Is it going to work?
Well, that was an interesting interaction there. If I was objecting to that, I would have asked for a sidebar immediately so I could explain that I believe this is outside the scope, in anticipation that the response to that might be, hey, she's given inconsistent statements in the past. That's in front of the jury now. Although it's just a statement from counsel in response to an objection, it's still there. And the jurors have heard that this witness allegedly made inconsistent statements in the past. And that's a credibility issue that hasn't been, formulated through testimony, but by argument of counsel. That's why you don't make objections necessarily in open court, because you can elicit responses like that that could be harmful to your case.
Oh, yeah. I mean, that was huge. The defense attorney was able to blurt that out, and now the jury's looking at this lady with a little side eye. Are you lying? The photos, though, of a boy with, injuries to his back, and he was in the care of the defendant at the time. Boy, I don't know. I don't know if this surpasses it or erases it, but I think that the defense is doing a good job, and the prosecutor missed the beat there. What now? If you're the prosecution, you really have to be on guard for the defense to continue down this road, correct? And so at sidebar, what are you telling the judge?
Well, I'm telling the judge that this is not really relevant to the case, that these issues could have been examined pre-trial in motions in limine and other things like that. Now, we have photographs, we have other supporting documentation. It's not really an issue of credibility with this witness. It's the photographs, the history of abuse speaks for itself. The defense is going to try to attack her and say that she's not credible. But how do you get over that hurdle of, hey, here's photographs of abuse, and there were charges that resulted from that abuse as well?
You put Thrailkill on the stand to tell his version of the story, saying I didn't do anything to little Martin, or is that like a lot of defendants a can of worms?
Yeah, that's a can of worms, because he gets up there and says something to the effect of, I would never harm him. And then all of a sudden, boom, all this other conduct of yours is relevant in terms of your the defendant's believability and credibility. So yeah, it would be a risk, but you have to evaluate the case before that decision is made, and ultimately it's the defendant's decision, not counsel.
Sure is. Matthew, thank you. As always, let's get a break. We'll have more Thrailkill out of Colorado when we return. Stay with us. This morning we were in Colorado for the father figure murder trial. Prosecutors say that the defendant here, Darin Thrailkill, strangled to death a 6-year-old little boy by the name of Martin. He was the boy of his girlfriend at the time. This was 10 years ago. The defense says that Martin suffered from asthma and other complications, and that's why Martin died. We're watching some key testimony here. The defendant's ex-wife's on, and she told the jury about an incident with her kids and this defendant, and showed photos of bruises and marks on the back of a youngster. Now she's on cross, and the defense is trying to make her out to be a liar. They've just finished up a sidebar. Let's go rejoin where we left off.
And so you spoke to DHS workers several times during their investigation in 2016 after Martin Osinski died, right?
Yes.
And during your conversations with workers at that point, you talked to Jackie Berry on July 7th, 2016.
Yes.
And you told Ms. Berry that you intended to kick out your then boyfriend, Zach Boiler.
Going to object. This is hearsay. She's not impeaching her on some other statement. This is hearsay.
Ms. Parham.
I'm not offering it for the truth of the matter asserted, and I'm offering it because it goes to the credibility for the reasons I've previously stated.
Okay. The objection's overruled. The jury's not to consider it for the truth of what's asserted in the statement, just for the purpose articulated by Ms. Parham and concerning the witness's credibility. Thanks.
And so when you spoke to Ms. Berry on July 7th, 2016, you indicated that you intended to kick out your then boyfriend, Zach Boiler, right?
Yes.
And then the next day, you also spoke with Ms. Berry.
I don't remember the exact dates, but yes.
That's fair. But you reported to Ms. Berry that you did, in fact, end your relationship with Mr. Boiler.
Yes.
And you are married to Mr. Boiler.
Common law.
You have a baby with him.
Yes.
You did not end your relationship with him.
No.
During the 2016 investigation, you also were in contact with Officer Gregory.
I don't remember the exact officer.
Oh, I'm sorry, I misread my notes. And so in 2022, you spoke with Officer Gregory, right? And that's when you reported that you had this baby with Zach Boiler.
Yes.
And you asked Detective Gregory not to tell Natalie Freeman.
I don't remember that.
And so I guess you indicated previously, going back to the incident in 2012, that you had information about conflicting statements from various people about how Sean got his injuries, right?
Restate that, I'm sorry.
And so you indicated previously regarding the 2012 incident that there was conflicting information that you received?
Yes.
Okay. You had information that he got the injuries from falling on a toy box?
I'm going to object to the hearsay. If she is intending it to be relevant that there was conflicting information, she's answered that. We don't believe the underlying hearsay is admissible.
Ms. Parham.
And I was just following up on the previous information that Ms. Thrailkill indicated that she had about conflicting information that she received during the investigation.
Are you offering it for the truth of the matter asserted?
Yes.
Okay. Ms. Mayor, did you want to say something else? And the microphone isn't pointed towards you, so thanks.
The only other objection I would add is 403, as well as hearsay.
Okay. The objections are overruled.
And so some of the conflicting information you had was that
Connor, could we approach the court?
Oh, sure. Feel free to stretch.
Okay, a sidebar there. The defense able to get out after, so the jury's seen these photos of these 2012 incidents, a boy with marks on his back, and it's, because the witness basically says he did it. This is prior abuse to another child. And now the defense has been able to get out this other narrative that there was a story that he may have fallen onto a toy box, and that's how he got those injuries. And during this divorce, she may have been lying about this for custody reasons, etc. We'll see how it plays out. Let's pick it up after the sidebar.
And this is just being offered for the credibility of this witness and the context of her previous statements. So I correct my previous assertion.
Okay. All right. So Ms. Parham isn't offering this information for the truth of the matter, what's asserted in the statement, just to help you in making determinations with regard to credibility and the context of the statement. Thanks. You can proceed.
And so going back to the 2012 incident, you had conflicting information about where these injuries came from, right?
Yes.
You had information that Sean got the injuries from falling on a toolbox.
Toy box, yes.
Toy box, sorry.
There you
Yes. That he got the injuries from falling off a merry-go-round.
Yes.
And if I could have 1 moment.
Oh, sure. I'm sorry, couldn't
And
you?
nothing further,
Nothing
sorry.
else. No worries. Ms. Mayor.
Well, just to follow up on that, Ms. Thrailkill, did you also have information that this was attributed to a hose?
Yes.
Did you have information that this was attributable to a sprinkler?
No. I don't remember a sprinkler. I just remember a house.
Were you there?
No.
So I guess my question to you is this information that defense counsel's asking you about, this is just information you've heard from other people, correct?
Yes.
Do you know what happened?
No.
Did you ever tell a judge that you knew what happened?
No.
Back in 2012, when defense counsel is asking you about the custody proceeding, did you fight for custody of your children?
Yes.
Did you earn primary custody of your children?
Yes.
What custody was earned by the defendant?
I believe his parenting time was restricted. He had to.
Well, let me just ask you this.
Yeah, go ahead.
What amount of time was he granted?
4 days, I believe. A week.
Okay, and that was back when you both lived here?
Yes.
Okay. Do you agree, at some point, defendant moved to Paradise Valley Trailer Park 2, correct?
Yes.
I assume that was super helpful for arranging children when you live in the exact same area.
No.
Oh,
I mean, yes, but no. We had conflicts.
okay. Did things become harder once you moved away to Denver?
Yes.
Defense counsel asked you about statements that you made to Jackie Berry at DHS that you had kicked out Zach and ended the relationship. Did that ever happen?
We did for a while.
So that's what I guess I want to ask you a little bit about. Defense counsel asked you about a statement that was made to Jackie Berry July 7th, 2016, concerning kicking out Zach and ending the relationship. After Martin died, were your children placed with Natalie Freeman?
Yes.
Were there guardianship hearings pertaining to whether or not Natalie had earned guardianship of your children?
I believe that came after the 7th. Yes.
Right. That happened after the 7th.
Yes.
Did you go fight for custody of your kids?
Absolutely.
Did you want your kids to live with you?
Yes.
When defense counsel asked you about getting married to Zach, when did you believe this marriage was before 2016 or after 2016?
It was before. We had been together for 6 months, and I guess by technical law or Colorado, we were already common law.
And defense counsel asked you a question about having a baby with Zach. When was that baby born?
February 12th, 2021.
And guardianship would have been determined roughly sometime in 2016?
Yes.
So the baby that defense counsel asked you about was born, what would that be, 5 years later?
Somewhere in there, yes.
Okay. Thank you. I don't have any further questions.
Ms. Parham, other questions?
And that was it for the ex on the stand. She did move the needle, one could argue, because of this allegation of a prior potential child abuse case. And this defendant is on trial for the death of a 6-year-old in his care. Prosecutors say he lost his cool when the 6-year-old little Martin, had a bathroom accident, and that was too much. That's what the state's alleging. The defense says no, Martin had some physical issues, including pneumonia and asthma, and that's why he died. Trial attorney, former prosecutor Imran Ansari is with us. Overall thoughts on this case? Good to see you, by the way.
Yeah, I mean, good to see you too, Ted. I haven't been on with you in a while. It's always a pleasure to be on. I mean, this case is a tragedy, right? Whenever you have a loss of life of someone so young, it's a tragedy. Now, here's the question for the jury. Was this an intentional murder or was this something health related? And, you know, the testimony we just saw from the ex-wife, I think, is supportive for the prosecution. If the jury is going to take that information and find that testimony credible, that, you know, there was abuse for another child in another relationship, and that this could have been the same sort of situation with an abuse from the defendant to little Martin here. So defense did a good job, though, I think, in the sense of trying to get out some bias as to why she would have made that allegation against the defendant for her child, and, you know, the custody issues, and whether that was a real credible injury at the hands of the defendant or something else. So, you know, you saw the needle being moved, as you say, for the prosecution, I believe, a bit, but the defense did what they could with this witness in terms of maybe raising some question marks as to her credibility and a motive to make an allegation of abuse against the defendant for her child during their divorce and custody battle.
The overarching picture that was painted by this witness is little Martin was in an environment of chaos, and it just seemed like things weren't buttoned up. Does that help or hurt the defendant?
Yeah, no, I think that's something that could suggest the prosecution's theory that this defendant just couldn't take any more of these accidents, and that if that chaos in that home environment was such that, you know, the defendant was in a situation where he may have snapped, right? And he couldn't take the situation with these accidents occurring with Martin, and therefore the strangulation occurred. So that chaotic environment, I think, feeds into this narrative from the prosecution that it was abusive. It was abuse at the hands of this defendant. And then, unfortunately, you have Martin as a victim of that abuse as alleged against this defendant.
Mm-hmm. Yeah, I agree. This is it's just a horrible case. By any measure, a little boy lost his life. And I think you could argue that his life was in an environment that had a lot of moving parts and was just not stable.